Preparing that presentation, I was thinking about that the main difficulty to engage in a comparative research is diving into a foreign system. So here am I talking about the Brazilian system, which you probably don't know that much about it. And thinking about this and related with socioeconomic rights, understanding the constitutional design and the role that socioeconomic rights have in the constitutional program, just like in Brazil, it's pivotal. In that field, the Brazilian system is totally different from, for example, the American one. It's a total different reality and also deeply different from others, different countries represented here. So to understand what is happening in Brazil, I will invite you kind of entering to the matrix. I was remembering the scene in the Matrix, the initial film, in the initial of the trilogy, in which Morpheus invited Neo to enter in the Matrix and offered him the blue pill and the red pill. But the good news is that in the Matrix movie, Morpheus says there is no way to hear about the Matrix. You should dive into it. But in that my theme, it is possible for you to hear a little about the Matrix, and if it presents to you as interesting, then you can dive in it. So that's why I'm doing here. I'm talking about a little bit that different matrix. Well, so to understand what is happening in Brazil and the points that I want to stress with you, I should expend some time talking about the Brazilian constitutional framework. You should remember the Brazilian constitution has completed 25 years last year. It was built in a moment of political transition in which we didn't have a revolution. It was a negotiated transition. And the Constituent Assembly were held in a political scenario of balance. We have conservative forces and we have progressive forces equally represented in the Constituent Assembly. So this results in a constitution that have particular features that I would like to stress with you. In the normative dimension, the Brazilian Constitution is an analytical constitutional text. Well, just like the other ones that were built in the late 90s and the early 21st century. We have about 300 articles, and it has an extensive list of socioeconomic rights. And why was the solution? Due to the equilibrium between the progressive forces and the conservative forces, establishing a large list of socioeconomic rights presented itself as a solution to establish an agenda of transformation, a political agenda of transformation. So if the socioeconomic rights were established, were listed in the Constitution, this would move the political powers to implement and enforce the socioeconomic rights. In the institutional dimension, we have, in the theme that I'm talking with you today, we have two particular features. We had a constitutional guarantee that is called access to justice, and it brings two features. The first one, if you are impoverished or if you are a needy one, you can have access to justice without paying any fee, zero fee. And you have an institutional representation that is created to provide an institutional entity that is created to provide legal representation in order to grant that access to justice. So if you are impoverished or if you're needy and you have a conflict with your neighbor, you can go to that institution. It's called something like the public defender and say, I have a problem with my neighbor, I want to file a lawsuit, and they will be able to do it for you at zero expense. And finally, in the rights dimension, we have a constitutional clause that assures immediate efficacy to all of the fundamental rights, including the socioeconomic ones. And this is quite different from the Portuguese experience, the South African experience, and other ones in which the Constitution also provides socioeconomic rights. And this was one of the ideas of the progressive forces. Well, let us list socioeconomic rights and grant them immediate efficacy, because this will put the process to go and the transformation that the Constitution intended to happen. And finally, we had a broad judicial possibility of scrutiny seen as an important mechanism, as a requirement to provide the enforcement of those socioeconomic rights. Well, that reality, that constitutional frameworks brought to the judiciary the idea that we have socioeconomic rights, they are provided with immediate efficacy, so we, judiciary, are supposed to give some kind of answer to each and every one who presents claim related with socioeconomic rights. So it's not a possibility to say, well, let's wait for the legislature to decide, well, let's wait for the development of a public policy. Judges feel in Brazil that they are supposed to grant immediately some kind of good or service due to the immediate efficacy clause related with socioeconomic rights. The reality that stressed all this perception started in the health system. Health is one of our socioeconomic rights granted in the Constitution. In the early 90s, the public health system was not going well. It was a real chaos. So people started to file lawsuits related with the right to health. And it was a very sensitive issue because, well, people were going to die if we do not provide any kind of public aid, of public service, of public goods. So it started in the health litigation, and it was established the idea that the judiciary can and should control the implementation of the socioeconomic rights. And that idea that started in that attitudinal model that started in the health field spread to education field, to environmental problems, and to housing rights, and to all of the other socioeconomic rights that we had provisions in our Constitution. Some of these rights are not easily granted in nature. If you have a housing rights conflict, a judge cannot make a house appear suddenly from nowhere. And then the problem that we got due to that attitudinal model, attitudinal understanding of the judiciary function was what I am calling the mercantilization of socioeconomic rights. And what am I calling mercantilization of socioeconomic rights? It's a judicial strategy of substituting the good or service contained in a socioeconomic right by financial aid or financial compensation. And we should think that judges go to law school in which we learn that if in an individual conflict, the solution that was originally provided or thought, it's not possible, you can grant financial compensation, and this will end the deal. This will solve the problem. So what the judiciary is doing is simply transplanting that idea that came from an individual conflict and using that kind of tool in socioeconomic rights conflicts. What led to that mercantilization, to the use of that strategy? Well, the first feature of our judiciary reality is that lawsuits are usually filed by individuals, and the citizens and the states are seen on a creditor-debtor relationship. So the citizen presents himself and says, The Constitution grants me a housing right, and I do not have a house, or my house is in a risk area, or I'm going to be reallocated due to public works. So I'm entitled to protection to my housing right. And this is seen as an individual problem. It's not seen as a part of a broader public policy. So this brought the idea of the mercantilization as a simple solution that the judiciary is practicing a lot nowadays. The second factor was the logic that the logic in handling jurisdiction in Brazil is still inspired by the Roman idea to give each one what it's due. So judges do not see with good eyes the idea that the solution relates not directly to addressing an individual need, but to perfecting public policies and other indirect effects. The third point that led to the mercantilization is the idea that I have already mentioned it, that financial compensation is the main tool that judges are used to apply in their lawsuits, so they're simply transplanting the idea. Coming to the end, I would like to stress that mercantilization is it's revealing to be a very regressive tendency when it comes to real enforcement of socioeconomic rights. And this is due to the following points. Financial compensation may not be enough to provide the right itself. For instance, in Brazil, in Rio de Janeiro particularly, we are going to host, the World Cup and the Olympics, so we're doing a lot of public works, we're doing a lot of reallocation, and the mercantilization solution was to grant something that we called social rent. It's a financial aid monthly paid by public administration. And this is what it's happening, and happening a lot. And this surely cannot provide the right itself. If you think about other socioeconomic rights, health, you have some kinds of pathologies in which financial aid won't solve the problem. Tuberculosis, for example, the medicine that is used to face TB, you cannot buy it in an ordinary pharmacy. So financial compensation may not be enough to provide the right itself. Financial compensation prioritizes the first-come, first-served treatment. And you will not think about the socioeconomic right as something to be attended in a collective perspective. And the public policy that is applied would be secundarized. And thirdly, financial compensation may stimulate some kind of trade-off between rights. There's a decision, a ruling of one of our courts, Superior Justice Court, in which the lawsuit was filed due to the following situation. Our prison system is in very bad conditions. They not meet the minimum standards required by human dignity. And due to the circumstance that rebuilding a prison system would take time and would take a lot of money, the requirement, what people want through the lawsuit was to be financially compensated. And the Superior Court of Justice says, we cannot do this. This would not solve the problem. This will create kind of a dungeon tool. The expression was in the ruling. This would create a dungeon tool. And this is not what the Constitution wants, surely not. A last remark in our subject. Financial compensation may not be enough to provide the right itself, I have already told. And the problem in a medium-term scenario is that this will bring a loss of control or overview of the real situation related with a particular right. If you give only financial compensation, you won't know where is, in which area of the city we have the most acute problems in housing rights, or in which field of health we have the most expressive numbers of lawsuits. Financial compensation prioritizes a first-come, first-served treatment, as I have mentioned, and this in the medium term will bring the inhibition of a distributive justice perspective and damaging also equality. And last, financial compensation may stimulate some kind of trade-off. So this can endanger the greater benefit that may come from perfecting public policy. And in this, I should point one public policy that is very mentioned when it comes to Brazil, and this is the family grant. Family grant has been pointed out as something that is transforming the Brazilian society. We have nowadays about 14 million families that receive family grant. This means that we have about 50 Brazilians that are beneficiaries from family grants. This is 25% of our population, about this. And last year, family grant have achieved its 10th anniversary. And the remark that people was doing is that it was entering in their second generation of beneficiaries. 45% of the people that was originally enrolled in family grant, still in family grant 10 years later. And their daughters and sons were building their own families and still enrolling in family grant because the financial compensation was not operating in the other fields. They were not providing employment, they were not providing education, they were not thinking about the bigger picture. So as a conclusion, I would like to point to you, or to stress with you, that the mercantilization strategies has a main flaw. The constitutional engineering in the Brazilian system is conceived as a double-track system. So in order to really enforce socioeconomic rights, you should think about that the rights themselves, but you should also think about the public policy. You will never be able to enforce socioeconomic rights in an individual basis, and the mercantilization is masking that approach. So it was a conquest of our constitution, surely. Socioeconomic rights is very important to help the transformation project, but as James will discuss, certainly, the newest of socioeconomic rights require new tools, new matrix of thoughts. So I've started with the matrix and I should end with the matrix. If we want to experiment really that new reality, we should abandon our original way of thinking and embrace a new matrix and replace it for something that may be able to really carry out a transformational project. Thank you very much.